We're just coasting along on 4CRB.
And a very good morning to you. This is John Fradgley from the Bell Legal Group, back with you for another program of The Law and You this Tuesday morning. Your opportunity to get free legal advice between now and 9:30. All we'd like you to do is get on that telephone as soon as you can. 55208888 is the number. That number again, 55208888. If for any reason you can't get access to the phone but you'd like to get a question through, you can always use our email address, talkback@4crb.com. So that's talkback@4crb.com. Don't forget, if you're phoning and you live south of the Tweed River, you need to put 07 in front of that number. Otherwise, throughout the rest of Queensland and in Tweed Heads proper, you can get straight through 55208888. And that was certainly very exciting that the secret sound went off this morning. I was saying to Barry Coleman a little earlier that I had actually worked it out. But I'd not said anything to anyone because obviously I can't enter the competition. But when I heard him announcing it on the radio as I was pulling in the car this morning, I quickly turned the radio off so I could walk in and speak to him and ask him whether I'd got the right answer. And sure enough, it was. So I think if I'd got it, there must have been a lot of other people out there listening who also had the correct answer, but for whatever reason just hadn't been able to get through. 55208888, that is our number. If you ring at the moment, you'll get straight through. So if you've got a question or a query, give us a call straight away, 55208888. I did mention to Barry this morning that I was going to speak a little bit about uncommon driving offences, which many of us would not be aware of. And what really brought it to mind was the other day I was driving along near home, and there was a car in front of me with a tiny dog that was basically, it must have been standing on the windowsill on the passenger side. The window was up, obviously, but with its legs hanging over and its head out the window, and it certainly looked like it was a reasonable distance out of the car. And I was just thinking to myself, boy, if that car was hit from the side or if they rear-ended another car, the damage to that little dog would have been very significant. And it just reminded me that travelling with a dog or an animal that is not properly restrained is in fact an offence under the traffic legislation in all Australian states, from what I understand. And I know in Queensland there were a huge number of people fined last year for driving without animals properly restrained. So if you have a little poochie and you're prone to drive around with them, for example, even in your lap, and you get spotted by the police, then you very well may be on the wrong end of a ticket for driving with an animal that's unrestrained. So please bear that in mind. The other one too that is, I think, becoming more of an issue as well is drink driving offences on alternative forms of transport. So a lot of people don't realise that you can be booked for drink driving if you're over the limit riding a bicycle, riding a scooter, and I should imagine it would apply to those electric scooters as well, a mobility scooter. So if you have one of those 4-wheel or 3-wheel mobility scooters and you're over the limit, you can be booked for drink driving on those, even on a Segway. I shouldn't imagine there'd be too many of our listeners who ride a Segway, but if you happen to, just bear that in mind. But enough of that. We've got callers online, and we say a very good morning to our first caller, Robin. G'day, Robin. How are you?
Yes, good morning. Thanks, John. Look, I heard something, I think it was you or somebody wondering on the Talkback programs, just touching on the issues with the public trustee will.
Right. Yes, I think that might have been the Friday morning talk.
Oh, yeah, that's right. Yeah. Is there something you can, because I have a will with the public trustee, so it's just a straightforward one with, no, are they still Was they saying it's not valid and to check?
Oh,
I'm not
no,
sure.
goodness me, no. There's certainly nothing wrong at all with a will prepared by the public trustee. So whether you have your will prepared by the public trustee or you choose to have your will done by a solicitor is purely a matter of choice. I have, over the years, where the public trustee has acted as executor, which is something that they seek to do to take on that role of executor. I have over the years.
Not the case with me. Yes.
Yes, well, that's one thing that people need to bear in mind, that if you have a will prepared by the public trustee, it's not mandatory that you use the public trustee as the executor. And just my experience over the years has been that many people have been frustrated by the length of time that is taken for the estate to be administered, changes in staff and things like that going through. But, I mean, obviously it's that old story, isn't it, that a satisfied customer will tell 10 other people, a dissatisfied customer will tell 100. So, you know, it's certainly not a condemnation by any stretch of the imagination of the public trustee.
No. All right. So basically, they must have been touching on some other aspect. They might have been talking about New South Wales. Have different formats.
Well, there have been some issues with the public trustee offices around Australia. I know there was a very high-profile matter. I think from memory, it was in Kingscliff recently, where a person who I think was a beneficiary under a will being controlled by the public trustee, and the beneficiary had been trying to get the public trustee office in New South Wales, or the public trust office in New South Wales, to effect repairs in relation to the property, and sadly the person ended up passing away, and they were in the property for some time before they were discovered. But when they were discovered, the property was was virtually falling down, and apparently something that led considerably to the depression of the resident or the occupier was the fact they couldn't get these repairs done. So it was a very sad case, and I believe that there's an inquiry going to arise as a result of that. All right then.
Yeah, fair enough. All right, thanks so much
Okay,
for that. I
Robin,
appreciate it.
all the very best.
Bye now.
And the time is just coming up to 13 minutes past 9 as we say a very good morning to Joy. G'day, Joy. How are you today?
Well, thank you.
That's good. How can we help?
Oh, is that John?
It is indeed.
Oh, okay. I'm busy listening to your previous story.
Well, just turn the radio down if you don't mind, otherwise you'll get totally confused because we're on a little bit of time delay and it'll really make life difficult for you.
Radio's down. I heard it on the phone.
Okay. How can I help?
I'm Joy, John. I rang you probably a couple of months ago. I haven't been well, and things have been left in abeyance. I rang you about setting up a trust for a purpose which doesn't exist in this country at the moment, and I would love to see it happen. I wanted to, and the idea of it was I have no money, but I have a house with some value in it, and it was set up at my death, and because I'm old and there's nothing to give, and you and I discussed the process of doing that, and it seemed to me reasonably straightforward. However, I've hit some snags, and I just would like to clarify a couple of things.
Sure.
Now, this is what I've been doing a lot of research, as you can imagine. I'm not quite a lawyer yet, but
sounds like you're getting pretty close.
Okay, so the steps that are needed, as I understand it, is that we have to set up the aims and purpose of the trust. It would need to be a charitable trust to avoid taxes because it's a church-related thing. It has to be registered, yes?
Yes, well, there are two issues. The first is whether you're setting up an inter vivos trust, which is one that you set up during your lifetime, or you're setting up a trust under your will. So they're the two alternatives. Well, an inter vivos trust is one that you set up during your lifetime, so the trust would all be set up now with all the purposes and everything in it, and you would presumably then do a will which left your estate to the trustee of that trust. Now, the alternative would be setting up a trust under your will, which is going to be the trust that will carry out those purposes, in which case the trust doesn't need to be physically set up at this point in time. What would happen is the trust would come into existence on your death.
Oh, okay.
So they're the two alternatives that would be available to you.
So the easier way would be the will.
I think the will would probably be the easier way, because then you don't have the issues of operating the trust or during your lifetime, and you can set out, I should imagine you can set out adequately within the terms of your will what the purpose is and who the trustees are, but you would need to cover off what is going to happen if the trustees are unable to fulfil your wishes, because one of the things that you would need to consider is what is going to happen to your estate if your intentions can't be fulfilled for whatever reason. So that would be another issue that you'd need to cover. But we'll just have to leave it there, Joy, because unfortunately I've got other callers on the line. But I hope that gives you a bit of help, and you can certainly look at perhaps establishing that charitable purpose or the charitable trust under your will. All right then.
Thank you very much.
Okay, Joy, all the very best. And the time on 4CRB just coming up now to 17 minutes past 9. That's, of course, 17 minutes past 10 Tweed Coast time. As we say, a very good morning to Elizabeth. G'day, Elizabeth. How are you today? Hello, Elizabeth. Are you there? Elizabeth, can you hear me? Oh, well, she appears to still be online, but we've lost the call, so maybe she's walked away from the phone because she was there was a little bit of a delay in getting to that. So we'll just take a break. We'll have a couple of messages from our sponsors, and we'll be back with more of the law and news shortly. Don't forget the number, 55208888. And Elizabeth, if you're now listening, please call back on 55208888.
Here's an amazing exclusive travel offer for 4CRB listeners only. Doug from our sponsor Costless Travel has great deals on a 15-day European river cruise in June of this year. Twin cabins from $3,498 per person and single cabins for just $3,998. Enjoy 15 days of relaxing luxury cruising, including meals, drinks and excursions from Amsterdam to Budapest, taking in Cologne, Nuremberg, Bratislava and Vienna along the way. Add an airfare from $1,298 and you're there. This is a one-off unique deal only for 4CRB listeners, and for every booking, Doug will also cover your next 5 years Radiothon subscription. Great for you and 4CRB. Call quickly before time runs out and ask for more details. Costless Travel. They really do cost less. Phone 1300 55 7388.
And this is the Law and You on 4CRB. Our telephone number 55208888. If you have a question or a query, we're fast approaching 20 minutes past 9. So if you have a question or a query you'd like answered, get on that telephone straight away, 55208888. I had mentioned earlier that I was going to talk about some of the unusual driving offences, and I finished at the start of the program. I was talking about the fact that you can be charged with drink driving of personal mobility devices, and the other thing that you need to be aware of is that that will also apply to riding a bicycle. So you could be charged if you're under the influence riding a bicycle. The other one that people don't think a lot about, though, is talking on their mobile phone. So if you're on a mobility scooter or you're riding along on your bike on the telephone, the rules equally apply. So there is the potential that you could be fined for doing that. The other one that's one of my real pet hates is people who drive around during the day with the fog lights on their car on. And it's not so much the lights at the front, which are low down and quite bright lights, but it's the what a lot of people don't appreciate is that if you turn your fog lights on, there is a very bright red light at the back of your car. Normally comes up in one of the brake lights, and it can be quite annoying if you're following a car that's got that light on, because you don't know whether they've got their brakes on or what's going on. And for that reason, you need to be aware that you can actually be fined for driving with your fog lights on during the day when there's no fog. So just be aware of that. But enough of that. We've got a couple more callers online. Elizabeth is back, so we'll have a very quick hello to Elizabeth. Good morning, Elizabeth. How are you?
I'm good, and you?
Very well, thanks. How can we help you today?
I've got a weird question, but I think maybe you can put me at ease.
Mm-hmm.
We're more than 20 years in this country,
mm-hmm.
and we paid super. Since we're in the country, we worked all the years.
Mm-hmm.
But I found out yesterday and a bit shocked. I rang my super and just wanted to find out. I saw the premiums is less, and why? She said the disability just fell away when I turned 67 last year. Is this legal? Is this normal?
Well, it will. So you're talking about the insurance component of your super, are you?
Yes.
Well, quite often those policies do have an age. So your disability cover very well may say that it is only in place until you're age 65. I'm pretty sure the disability insurance that I have associated with my super does in fact cease at 65. And in fact, a lot of the life cover that's associated with superannuation is also what's referred to as term life. So it may in fact cease when you're 65, 70, 75 or whatever. So, yes, it's all to do with the terms of the policy that you take out at the time. And I suspect what may have happened, Elizabeth, is over the passage of the years you've forgotten that you were told this at the time, and probably if you took it out 20 years ago, 65 seemed like a lifetime away and you weren't too worried about it then. But it does certainly become an issue now.
But even the life one, I can't believe that it will fall away when you're 70, but the government still wants you to keep on working, which we're doing because we can. We still...
yes, but that's got nothing to do with you. That's got nothing to do with your superannuation, though. That's just an add-on to super. You will still be contributing to your super if you're working, and your superannuation will all still be in place. The only thing is that
your insurance fell away.
But if you were to die before you're 70, well, obviously the insurance will be paid out to your superannuation, to the trustee of your super, and with the disability that will be paid out directly to you. But that's a very common provision in these policies, I'm afraid.
Yeah, we're a bit shocked. We didn't know, especially the life one.
Yes.
When you die, then your husband gets nothing. When my husband died at 25, he's super. Yep. Then there's no money for me coming out there. I'm talking about insurance.
Yes.
Okay,
sorry, Elizabeth. Sorry I can't be the bearer of better news. All the very best.
No, that's okay.
Time is coming up to 24 minutes past 9 as we say a very good morning to our patient Bill. G'day, Bill. How are you today?
Oh, good morning, John. Well, thank you.
That's good. How can we help you today?
Where there's a life tenancy from a will, what's the situation in relation to the resident's contents, and who's responsible for the rates and insurance going forward?
Well, that will depend on the terms of the will. So the provision for a right to occupy or a life tenancy needs to be set out in the will, and the will normally, certainly where we draft wills that contain provision for a right to occupy, it will say that the person has this right to occupy as long as they maintain the property, maintain the insurance and pay the rates. So they're quite normal provisions that would go in a provision for life tenancy. As to the contents of the property, well, that will depend on whether the will says that it includes the contents or not. So with those things, it's quite unusual. I don't think I've ever drafted a will that's had a life interest in the contents other than, for example, a situation. Normally what you would do is if you had a husband and wife, and one spouse wanted to give a life interest to the other, normally what you would do is have a provision which says that, the contents is given to the life tenant as an absolute gift, and then they have the life tenancy in the property. If there were particularly valuable items in the home, for example, antique furniture, which was worth a lot of money, well, in that situation you may, in fact, set it up so that there's a life tenancy in relation to those items as well, and there would need to be provision about who was responsible for maintaining those items, etc. But there should always be a provision excluding fair wear and tear.
I know, but if the will is silent in relation to the rates and insurance, what then?
Look, if the will is silent in relation to those items, then the property presumably remains registered in the name of the executor under the will, and I would have thought that it would be the executor's responsibility. But that would mean then that they would have to pay those things out of the residue of the estate.
Yes, yes.
All right.
Thanks very much. That's
okay,
good.
Bill. All the very best. And we have one last caller online. We'll say a very quick hello to Mike. G'day, Mike. How are you today?
Good, thanks. John.
Yes, how can we help?
I had a new house built. Finished about 18 months ago. There was a house and land package from a major builder on the coast. There were several, I think there was 4 items which are included as sort of a special deal. One of them was an enlarged front door and a upgraded kitchen. There was a few things like that which are all included in our price. One of the inclusions as an extra was carpet to 3 rooms. It was about $1,000 worth. And that was all sealed up. And about 3/4 of the way through, they advised us that the carpet, they weren't going to do the carpet and they had a reason for that. It's because I'd agreed to paint the place myself, because I'm a painter. And that was fine. They went along with that. But they didn't say anything until it was almost complete. And I said, oh no, because you're painting it yourself, we're not doing the carpeting. We're not... and I always thought that was just ridiculous, actually. And I wondered if it wasn't straight out breach of contract.
Well, if the contract says that they're to supply the carpet, then clearly that's what's required. Without looking at the contract, Mike, obviously it's a little difficult for me to comment further. But at the very least, they should reduce the price by the PC value of the carpet that was included, so that you... I can understand why they would not want to put the carpet in until the painting's finished, because, there's always a risk of damage to the carpet, etc., so that's understandable. But the other side of that is that, if you are agreeable to sign up and say, no, look, I'll accept it carpeted, and I'll take the risk on the painting damaging the carpet, well, equally I would have thought that was a reasonable outcome as well.
Yeah, we didn't have any options. They didn't give us any options. I did say, well, what if you just deduct $1,000 off what we owe?
And what did they say?
No, they weren't interested.
Well,
in
I think if they weren't prepared to do that, then I certainly do think that you would have a claim, particularly if that item was PC'd and it was the builder who said they wouldn't do it. So I certainly do think you do have a claim for the $1,000. All right.
Yeah, I think we should be sure. Thank you very much.
Yeah,
no,
I would certainly do it. You could perhaps write a letter of demand, maybe speak to the Queensland Building Services Authority, and if all else fails, go to QCAT.
Yeah, all right, okay. Thanks for your help.
All the very best, Mike.
Yeah, you too, bye.
And the time on 4CRB is nearly coming up to 9:30, which of course is 4CRB local news. This is John Fradgley from the Bell Legal Group. It's been great to be with you this morning for another program of The Law and You. I'll look forward to being back with you next week. But as always, until then, goodbye and God bless.